Thank you so much for joining us today. We are so excited to be here to learn more about the California CARE Act and super honored to have an incredible panel discussion with four individuals who are just change makers in the mental health field and come in with so much passion and expertise, who I will be introducing shortly. My name is Amanda Lipp. My pronouns are she, her, and I work for the Center for Applied Research Solutions. And I will be your moderator for today, your host, if you will, walking through some questions, posing some questions, and helping facilitate this dialogue today. And here's a little bit of a show flow of today's content. So basically about 35 minutes will be focused on providing you content from our panelists and walking through the presentation. And each of our panelists have prepared their own little mini presentation. And then we'll open it up to these questions for our panelists. What are the concerns? What are the opportunities? And also zoom in a little bit on community services and housing. An incredible group here with us today. We have Dr. Veronica Kelly, who is the Chief Mental Health and Recovery Services at Orange County Healthcare Agency. So really excited to have Dr. Kelly's perspective, behavioral health systems and the public health system, and really the boots on the ground from that county perspective as well. So Harold Turner, the executive director at NAMI Urban Los Angeles, and also wearing that hat from that family perspective and how might the CARE Court Act affect families. So really, again, that boots on the ground perspective and just incredible experience. So really thrilled to have you here with us, Harold. Honorable James Bianco is assigned to a full-time mental health courtroom in the Criminal Justice Center in Los Angeles, handling felony cases in which people receive community mental health treatment. So just so honored and thrilled to have Honorable James Bianco here today to have his perspective on the court system. And last but not least, we have Christopher Schneiders, the former director of the Sachs Institute, which is held at USC under the Mental Health Law and Policy at Gould School of Law, and also bringing in that peer perspective and talking about self-determination, supported decision-making, and psychiatric advance directives. So just a wonderfully diverse representation today, bringing in different lenses, perspectives, and expertise on the CARE Court and how it might affect people, families, and our system. So thank you again to our wonderful panelists for being here today. And I will now pass it on to our first panelist to talk about what is CARE Court. Dr. Veronica Kelly, take it away.
I'm going to just do the overview of what CARE is. Orange County is one of the first cohort counties, and that means we have opted in early to try and help guide this development of CARE so that it makes sense and that it helps us and doesn't waste time or money or opportunity. And so I'm going to be speaking from that perspective as we get ready in less than a couple of months to open the doors to our process. Next slide. So CARE, Community Assistance, Recovery, and Empowerment. It's the court part. It has stuck. It's actually known as the CARE Act, but because part of it occurs in a court, and it started out as CARE Court, that's really where we're going. So this is civil court. This is not criminal court. It's really important for people to remember that. And this really is supposed to focus counties and other governmental agencies on serving people who have untreated schizophrenia spectrum or other related psychotic disorders, provide behavioral health and other related resources to assist that individual, absolutely protect self-determination and civil liberties, and then really to intervene sooner rather than later in helping somebody meet and achieve their goals. These are the folks who are eligible to participate in this program. You have to be an adult who's 18 years of age or older. You have to be diagnosed with schizophrenia spectrum or other related psychotic disorders. So if somebody, if I wanted to get my son into CARE and he has methamphetamine-induced psychosis, so he uses a lot of methamphetamine that makes him psychotic, he's not doing well, I'm very worried about him, then he would not be a candidate for this because his diagnosis is not schizophrenia spectrum. That also would include diagnoses such as schizoaffective disorder or psychotic disorder not otherwise specified. It's very important. That is the small, narrow window of diagnostic criteria that CARE has become. It didn't start that way, but that's what the law is right now. The person who is being considered for the program has to actually be experiencing crisis. They have to have behaviors and symptoms associated with severe mental illness, because a lot of people have schizophrenia and a lot of people do fine and do well. And so this is for people who are untreated. And the next one, they're not clinically stable and they're not in ongoing voluntary treatment. I have a lot of folks that we serve in our system here. No, schizoaffective disorder would. I saw the question. I know I'm probably not supposed to answer it yet, but anything under schizophrenia spectrum disorder. But you have to meet all these criteria here. So it's not just a diagnosis that's really important. We're talking about people. So we're talking about the illness that's affecting people. So lots of folks have schizophrenia or schizoaffective disorder or some other psychotic disorder. And even a lot of those folks might actually be unhoused. That doesn't mean they meet immediately, that they immediately qualify for this program. So that's important to remember too. They have to have one of the following. They have to be unlikely to survive in their current state, or if they don't get services now, they will be unlikely to survive. Remember that CARE, the participation in this program, would be the least restrictive and that they would likely benefit. So all of those things are important. This is the target population, which again goes from lots of folks to a very narrow group of people. Point out a couple things. This is not the program where you call the county behavioral health and say, hey, I know somebody, can you come get them? That is not what this is. If I was interested in getting my loved one into treatment because perhaps they're languishing and they meet the criteria and they won't go any other way and I don't want them to die, I would then petition the court. I would go to my courthouse and I would file paperwork. There are specific petition forms that the Judicial Council of California has created. There are a number of required forms, and all of those forms, all the lines on the required forms have to be completed. Important to know. But a person who lives with somebody who might need care or benefit from care can file a petition. A spouse, a parent, siblings, adult children, anyone who's living with a roommate can all file the petition. The person who is experiencing the untreated, the schizophrenia that's not being treated could also get themselves into treatment. In the community, a first responder, like the paramedic who might be responding to your house over and over again to try and help you with your adult child, that person who has knowledge of what's been happening with your child, your loved one, could file the petition. The director of a hospital, whether it is a regular hospital or a psychiatric hospital, could file a petition, especially if they know that that patient, that individual has come to the hospital over and over again, is not doing well. A licensed clinician could file a petition. The director of a community-based organization who provides behavioral health services. So the Wendy's down the street can't, that's not a person who could file unless it was for their own loved one. But an outpatient clinic that used to see someone, now they see them outside and they're not doing well, they could file. The county behavioral health director, which is what I am for Orange County, the public guardian could file. And that would be if the public guardian was working with someone who wasn't quite meeting criteria for conservatorship, but they thought this might be a least restrictive way to perhaps offer services, they could file. The director of adult protective services could file. Remember though, this is for schizophrenia spectrum disorder. It's not for dementia, even though there might be psychosis with dementia. It's not for, like I told you before, addiction, and that's not the primary diagnosis. It has to be schizophrenia spectrum disorder, which does include schizoaffective disorder. From our tribal community, the director of California Indian Health Services program could file a petition, as well as the judges who are in tribal court. So you would complete the forms. The forms are listed. They're not available yet because this hasn't begun yet. So October 1 is when we go live. That's a Sunday. I don't think we hold court, right, Judge, on Sunday. So it'd be Monday, October 2nd. In addition to filling out the paperwork, again, this is really important for you all to understand, and for all of us, that's what we're trying to get the word out, that you have to have one of these things. You have to have completed a mental health declaration from a licensed behavioral health provider that says, yep, my son has schizophrenia, or evidence that the person that you're trying to seek treatment for was detained for a minimum of 2 periods of intensive treatment. And the legislation says intensive treatment is 50-50 holds. So at least a 2-week period that we have someone on a hold to be able to figure out if they are able to help in their own care. And the most recent episode of that 50-50 hold has to happen within the last 60 days. So it is very, very prescriptive. So the judge is going to talk about about the process here. I think you'll have access to our slides, and this is Orange County's process. It seems complicated, but what it is there are multiple points where a case could be dismissed for someone not meeting criteria. Remember, this is voluntary. The number one thing that I think is important to know is that what we want to do is help an individual meet their goals. Even though mom might be the one who's trying to get them into treatment and wants them in a hospital, if they don't meet criteria and that individual doesn't want to go to a hospital, I can still help by figuring out, what do you want? Is there something I can help you with? And start to build a relationship. That's the thing that County Behavioral Health is going to look at, is trying to build a relationship with a person to get them to the goals that they need, with the hopes that after a lot of high touch activity, we can get them into treatment that would help them and also help our community. Next slide. This is a long slide. So next slide, that's just the continuation. The care plan is just the writing out exactly what the patient or the identified person wants to get done. We can talk about this maybe in questions, and if anyone has a question about how this differs from some of our current collaborative courts. And these are just an array of services that Orange County offers. I have 400 programs, so that there's something probably that would be able to help an individual without having to go through the care process. And this is just a QR code if you want to take a picture of it, that will take you to our website, the OC Navigator, that has resources for us. And I will be here to answer questions at the end. So thank you.
Thank you so much, Dr. Kelly. Really appreciate that presentation and grounding us in really what the CARE Court is, what the CARE Act is. Honorable James Bianco handles felony cases in which people receive community mental health treatment. So I'll let James Bianco take it away.
Good afternoon, everyone. So I just want to hit some high notes about the court process, and from the perspective of someone who's been doing mental health cases for many years, both criminal and conservatorships, and really the whole range. You know, there are 58 counties in California, and I think what you're going to find with CARE Court, as you do in many court processes, is there are going to be 58 different ways potentially that the process is given life by the court and the counties. The CARE statutes are, like most statutes, they outline the process at least to some degree, but there's certainly gray area where the court and the county behavioral health agencies are sort of hard at work right now, sort of fleshing out exactly how things are going to work in each particular county. The other, I think, really important takeaway that I want to emphasize, and Dr. Kelly mentioned this as well, is that CARE Court is a very targeted effort to address a particular population of people in California. It doesn't apply to everyone who needs help. It doesn't apply to everyone who could possibly benefit from the CARE Court process. It just applies to the people that meet the criteria that Dr. Kelly outlined. And the state's estimate is that in the entire state of California, with 40 million people, we're talking about 7,000 to 12,000 Californians that would meet CARE criteria. So let's move to the next slide. this is another kind of complicated slide of the court process. I'm just going to kind of give you a very high level overview. So starting to the left of the red box, the initiation of the case, as Dr. Kelly mentioned, is very different than most other processes in the mental health world, such as assisted outpatient treatment or a conservatorship, for example, where the county behavioral health department or some part of those departments have to file the petition. Care court is different because it really throws open the doors to the courthouse. It allows family members, roommates, first responders, and so on. I mean, Dr. Kelly went down the whole list. 12 different categories of people or entities that can file a petition. Having thrown open the doors of the courthouse, this then puts the burden on the court to look at each petition to decide if it meets all the criteria. So we could put that red box back up. The first step in the process, yeah, there we go. The first step in the process is for the court to review the petition that's been filed and determine if a prima facie case has been met. Prima facie basically just means, does the petition meet all of the criteria that are outlined by the statute? If the answer is yes, then it goes forward to the next step of the process. If it doesn't meet criteria, the statute says that the court can dismiss the petition either with or without prejudice. With prejudice means it can't be filed again, and the court can only make that order under certain very limited circumstances. Without prejudice means that it's dismissed, but the petitioner can try again. It's possible, it's not in the statute, but again, it's possible that some county or counties might adopt a slightly expanded process where rather than dismiss it, if a petition is insufficient, there will be some way of notifying the petitioner, hey, we're not accepting your petition. We find that it doesn't meet all the criteria, and here's why. This remains to be seen, how counties are going to do this in each county. We are expecting a great number of petitions to be filed. In fact, I think in some counties as large as Los Angeles, there may be one bench officer whose job, at least initially, is going to be to just evaluate petitions. It may be that much of a sort of onslaught of paper once the doors to the court open. All right, so once the court makes a prima facie determination and it moves to the next step, the proceedings by statute are supposed to be informal and non-adversarial. The person has the right to be represented by an attorney. They also have the right to have a support person in court, and that's kind of different from any other mental health process in the court system that I've ever been aware of. And I think that's one of the things that makes the CARE process unique. The process itself, once it's initiated in court, is going to involve a lot of different hearings, a lot of different steps. I don't want to go through all of them, but as you can see, there are opportunities at each step of the way to have input from all the parties to try to create a plan that'll work for that person. And then when we get to the next box, if we can move that red box over one more step to the right, there are progress and status review hearings. The process is supposed to last 1 year, and then there's a possibility that it'll be extended for another year under certain circumstances. You know, CARE, and it says this right in the statute, that it's to try to get ahead of the process, you know, where someone's arrested and ends up in jail and then needing to be sort of diverted into treatment, or a conservatorship, which can be very restrictive, or institutionalized on an involuntary hold. CARE is a way to try to get people who really need treatment, who need housing, who need sort of wraparound services, to engage in those services and have those services provided for them by the county before arrest, before conservatorship, before institutionalization. So I think it's something that we all ought to be excited about, and I think holds some hope for the folks that would meet the criteria. So let me pass it back to you, Amanda.
Thank you so much, Judge Bianco. Really appreciate your perspective and thoughts around the Care Court. And next up, we have Harold Turner, who has been a contributing member of NAMI since 2007 and is currently the executive director of NAMI Urban Los Angeles. So let's virtually give it up for Harold and passing it over to you.
I'm really interested, in my experience as being a family member caregiver for someone living with a mental illness, is the importance of the role of family in getting people on the road to recovery and sort of ensuring their success. Part of that is being a part of the care team and a part of the plan for that care team to be able to help your loved ones to move along the road again to recovery, to help them live as full a life as possible. And that comes with the, with the family history, knowing the individual. And sometimes that's a continual learning experience, information sometimes only the family has that can be provided to the care team in figuring out what are the appropriate plans for the individual. The family history, the medical history they've had in addition to their mental health history, any developmental issues that the family member may have experienced early on, and sort of a chronology of the onset of mental illness. What did that look like? When did it occur? Sometimes the family knows it. I continually learn things about that. My loved one was diagnosed at the age of 21, but subsequent conversations with her indicated she may have started experiencing symptoms as early as 15, but not brought those experiences forward because of the stigma surrounding mental illness. You can see, what their academic history is. In my case, it played an important role in the individual's self-image, my loved one, and kind of how she viewed success, and for her, it was as long as I'm achieving academically and staying with my peers, it proves that I don't have a mental illness. So it was, later on, we were able to find all kinds of verifications of that thought process, and it kind of paralleled her commitment history. And also a work history, anything that may have been significant in either providing some sort of relief from mental health systems or mental health symptoms, or strictly work related, the type of work that they were drawn to. We also know that the treatment histories. The treatment histories sometimes can be long and circuitous, but the family members know that and are able to articulate that. And I think work with the teams so they understand what has and what has not been effective for the family member, either currently or historically, what that's been like. What were the past experiences in dealing with certain treatment modalities. Again, all of this is information that the families have that they can provide to the care team that may prove to be instrumental in determining what sort of treatment modalities to follow. what kind of outcomes are you looking for from the mental health court? Or was a big one for me. I looked at this and almost looking at it in retrospect, looking at my own experience and what that might have looked like had we had access to care courts, you know, when I was actually experiencing this situation. And I dare to say, I think it would have been much different. The key factor to me is the review and the progress reviews that go on with the individual to determine how well they are progressing along with the goals that they've jointly established with their supporter or family member, in the progress that they're making in that, any issues they may have encountered that could be a setback or alternately, you know, expedite their recovery.
Thank you so much, Harold. And now, last but not least, Christopher Schneiders, the former director of the Sachs Institute for Mental Health Law, Policy, and Ethics at USC Gould School of Law. So, Christopher, please take it away.
You know, I'm kind of speaking from the peer lived experience perspective, but I wouldn't qualify ever for care court, and I think we all know that there's near unanimous opposition to this from those communities and the disability organizations and the homeless organizations. My perspective and the perspective working with Ellen Sachs and Sachs Institute is something that is something that's happening, and you know, let's look at what it is. And what I see is a lot of self-determination language we want to see, and we see supported decision-making, those words in there, in psychiatric advance directives. And after doing years of research and work in this area, it's you know, exciting to see that this language is becoming part of law. The main opposition, of course, is that this kind of is forced treatment. If this court order is forced treatment. So I'm just going to read through a few of the slides I put together. All too often, the voice and wishes of people with psychiatric disabilities are neglected during on the ground or real world mental health crisis events. There's many reasons for that, but we want to change that paradigm. And at the core, the basic tenets underlying SDM and PADS for people with psychiatric disabilities, which is a term I use, everyone can use their own, are autonomy, self-determination, and choice. Right, so what is supported decision-making? And this is an international paradigm that's recognized by the Convention on the Rights of People with Disabilities. And the US is not a signatory on it, but SDM was recognized and put into the language of the CRPD Article 12 in 2006. And it basically recognizing a person having full rights as a person. Supported decision-making, which is not shared decision-making, is where people choose their supporters to help people make their own important life choices. And that resource center right there is a very important place to go to. But when we're talking about CARE Act, the words supported decision-making are in the law, not shared. So part of my hope is that we're going to be using common language. So, and then now we're talking about psychiatric advance directives, and there's a bit of a zeitgeist going on, you know, internationally and nationally, where there's consumer groups, there's researchers, any number of different organizations, and you know, mental health behavioral departments are becoming interested in what a PAD is, and it's really a legal rights document, which is unique, that it can record a person's preferences for future mental health treatment, you know, if they're going to have potentially another psychotic episode. And this sounds difficult, and it will be difficult and complicated, but also This is an opportunity for someone when they're competent, and people with mental illness are competent a lot of the time, echoing Dr. Kelly, and in schizophrenia, through my work with Ellen Sachs and many others with schizophrenia, who have been in hospitals for years and years and years. There's a future, there is hope, and there is, a real full life that's possible. There's also incredibly difficult, seemingly unmanageable situations, for families and everybody else. And that's not to be denied. But this isn't something that's been around for 30 years, and we're getting some more movement on that. So it's exciting to see it in the care law. And the promise of PADS is a psychiatric advance directive, it's a legal document, and it can allow you to put your wishes. What medication do you want? If you're encountering first responders or law enforcement, what names should they use? How should they stand, at 45-degree angle to block doors? What hospital you may prefer, and who's going to take care of my dog, or my money. These kind of things you can lay out. And an important part of that is that they identify their own chosen proxy decision maker, which could be a parent, but it's important that this person is chosen and that can commit to be there if there is a psychotic episode, and try to communicate those wishes all along the line, so that the wishes are listened to, mostly to reduce trauma and to create better care throughout the process. Their question is obviously, and it comes over and over, okay, you're a psychotic episode, and you're going to change your mind about everything. Say, I don't want to do any of that stuff. Yes, it's confusing, difficult, something we need to work through. But if there is a committed proxy decision maker, and there's information on how best to deal with the situation, as opposed to traumatic force, I think it's worth trying, and it's very exciting to see that in the care law. Next, there's lots of information out there, but it documents crucial information, like I said, for law enforcement, crisis intervention, emergency medical personnel, on and on. And what a PAD does is it's kind of like a menu. You don't have to put everything in there. You put in what you choose to put in there. And what's different from, say, supported decision making, which is the paradigm, is that it's legally binding, but it won't be legally binding if it's not used, if there aren't enough PADS. It's kind of like a supply demand, and if there isn't buy-in from all the departments, agencies, silos, and people involved there. And the other part is, like, I've done some research or tried to do some initial steps into first response, and that's an interest in my mental health crisis events. And there's a real potential for de-escalation. Talk to police officers, talk to emergency room doctors. I'm sure many people that work for Dr. Kelly is like, if I had this information, I would love it, but how do we share it? How do we get it to the people? Because it's traumatic for everyone when we have, restraints and worse. So that's, it cannot be communicated and transmitted is a big question. All right, so yeah, I think I have some information, preferences for emergency response and treatment, ways to reduce and avoid emergency treatment, and quote unquote treatment, and use of force. They're very trying to change that use of force paradigm in approaching people with mental health crisis situations. We know that it doesn't have to happen that way. What can calm it? What can make the situation worse, and how can we work with that information? Medical, mental health treatment choices, like I said, medication, and also a lot of just real world application, like who takes care of my things, that you can decide ahead of time. And then the supporters and proxy decision makers, as I mentioned, super duper important. And if you're really practicing, is chosen supporters, family members like Harold and many others that I've talked to are absolutely the right people that have so much love and care and investment. Other families, as we know, isn't that would not be the case, and could cause additional harm. But so the choice and the buy-in from the individual saying, I have a voice here is super important. And that's why I that's what I like about the CARE Act is a continual self-determined language, self-determination. And Ellen Sachs has often talked about the right to refuse medication. It's upset many parents, understandably. But if a person has a right to say no, then also they have, when they choose to buy in, then they say, this is my choice. So we're trying to get more of this choice and autonomy, and supporters can be real important parts of that if they understand that, ultimately the choice goes to the individual. That's what supported decision making is, as opposed to shared, that the decision making is supported. So what name you want to be called, not Jonathan, but John, or any of that. And don't look me in the eye, or look me in the eye, and stand at these angles. And I think we all understand what some of the law enforcement tactics, which are quick rushing in. And I know that there's a lot of work with the SMART teams and other collaborative ventures as far as crisis response. But just types of things like this, and specifically this last one, what doesn't, preferences when not competent, medication, examples, seclusion, and then restraints, must be a last resort. It is traumatic for everybody, and it's not to say that, it isn't necessary. I guess it's not necessary, but it might happen in settings, but that's got to be a last resort, because people die in those restraints. So Pat, so I'm quoting Richard Bonney here, a psychiatrist and legal psychiatrist in Virginia, and it's shifting the legal model of care, even in crisis, from coercion to contract. So here's the contract. Here's the legal rights that you have, and that I'm outlining. It values and respects the rights, wishes, needs of consumers during psychotic episodes. Communication and continuity of care between silos, agencies, and departments is really important to make this thing happen. And potential outcomes: less trauma, less paperwork, I hope, lowered recidivism, there's choice involved, and there was just a study out of France, and the reduced costs are there too. And so that's pretty much kind of an overview of what we're thinking in the terms of self-determination, and some hopes of the language in this act.
What are some things that you feel like might be red flags, or that you anticipate, or that are already happening?
From the provider perspective, managing expectations is a huge concern. This has been stated as so many things, and the answer to everyone's prayer. And what we're trying to do is really manage everyone's expectations. Another concern is that there's this timeline that's ridiculous. The county is tasked with, once that petition makes through the process and prima facie is found, the county has to go locate the individual. So my clinicians have to go out on the street and locate an individual and try and get into your home to locate the individual. So that's a very long-term process. We know it takes probably, and I was the county behavioral health director in San Bernardino County, and we did something similar to this without care, without the court. And it took 40 face-to-face visits before an individual would trust us to actually listen to us. But once they did that, 90% of those individuals with serious untreated illness activated voluntarily into treatment. 40 face-to-face. What this gives me is 14 days to find a person and get them in, and to serve them. Find them and say, hey, you got to get to court and talk to them. The timelines are too restrictive.
The court can sanction a county if the county's not complying with the court's order to provide what's in the care plan, but the court has no ability to force anyone or require anyone to any participant in care court to do or to follow the plan. So in other words, the person who's subject to the care petition, who doesn't want to be involved, really, there's not much the court can do. And so we're going to be in a position of, trying to use what some call the black robe effect, to try to convince or cajole or nudge or, sort of plead with the person. My hope from what I've seen is that, a lot of people who are in need of treatment, if you offer them really good treatment with housing, they will want to do that, and you won't need to plead with them at all. But there are also people who really want nothing to do with treatment, either because of past experiences or restrictions and rules that they've got to follow in housing, or sometimes substance abuse, or some combination of all those three, who just don't want to engage at all. And I think those are going to be people where we're going to have a tough time getting through to them and succeeding with them in care court.
Yeah, I think just the concern I have in my experience is really where it's possible, incorporating the family again as part of that care team. Have some really pertinent information that they can provide to help, get loved ones, or or what do we call them now, responders, to agree to follow a treatment plan. Is without the families and the families providing what they found to be successful, and those things that they found not to be successful, and the things that are counterproductive, is very important. And without care courts, there was no way for that to happen consistently. And I spent years, and trust me, trying to elbow my way onto care teams to have some say so and provide information and knowledge that I had that they couldn't possibly have to get that accepted. So I would hope that part of the plans that be reviewed would definitely involve the families where that's possible. I know that's not possible or wanted in all cases, but where it is, I believe that can be a tremendous asset.
Yeah, concerns are definitely that it's forced treatment. It's not voluntary. Some of our politician friends have said maybe that it's voluntary, and it's voluntary to, I guess, enter into this care process. Another one is what is the care plan, and how does that work, and what is the consistency with that, and how individualized, and how we're going to listen to the individual. And the big one is housing and community services, because it says in the law that your graduation is in housing and community services, but as far as I hear, that's not there, or there isn't enough of it there. And what what really need, and I see the comments about the expense, and yes, is a massive investment from our state and voluntary, walk-in state-of-the-art community services and some smart housing investment, but also just taking it for what it is.
Just kind of flipping the script a little bit, what are maybe some opportunities or strengths, or why the Care Court or Care Act is different?
From a county perspective, we opted in because we didn't want to have something done to us and to the people that we serve. So we wanted to be able to try and craft it so it makes a little bit more sense. So it's an opportunity right there. And it is an opportunity to offer services to people that I don't know about. I can't go on to every of the 3.2 million people in this county and see if they need my help as a county behavioral health, right? It also allows us to serve people who have insurance. And usually if you don't have Medi-Cal, we don't serve you. We serve people who have no insurance or Medi-Cal. The law will allow us to take folks who have insurance, and the insurance company is going to have to pay. And that's a very big opportunity, a very different thing. Our private insurances, the insurance that many of you pay for your adult children, have a role to play in providing good care, and they've really been absent.
You know, I see this as another step along the way of fixing a problem that we started many decades ago. You know, in the 60s and 70s and early 80s, we closed all the institutions in the US, which I think was a very good thing. And the idea was to create community mental health centers that would provide for the needs of people with schizophrenia and other psychotic disorders. And we never really built that system. So we lack housing, we lack treatment professionals, we lack capacity. And I think we're really scrambling to try to catch up. And I think the CARE program is, like I said, another step along the way to create care for people that most need it in California. To try to continue to build out that community health system that we never did in the past.
Much like I said, in my part is just seeing the language of self-determination, seeing in my mind the first time that support decision-making is going into law, seeing the first time the psychiatric advance directives are as mentioned as something that can be done here as part of the care plan. This is exciting stuff to me, although the court process is going to be scary and difficult, and we have to admit that we need to do something for our brothers and sisters who are homeless and severely mentally ill. It seems like an almost impossible problem. Trying to introduce some self-determination into that is a potential opportunity.
In my case, had care courts been in effect, and the ability to review that plan, I had a loved one who was in the highest level of care that we have in the system, and could really been out of that about 10 years sooner, if care courts had been there to ensure her rights and review the plans that were in effect, and hold the developers of that plan accountable for the progress in that plan. That can be so frustrating and disheartening for individuals who are really wanting to move on with their lives and have done everything within their power to do it, including finding jobs that were willing to make accommodations for the situations they found themselves in, but yet finding having a system unwilling to give them the opportunity that an employer would take on them. So that is very frustrating, to the extent that it gave up and returned to that higher system of care rather than be into a program that would not allow them to, in their own opinion, be successful. And as a family member, it's very hard for me to argue with, having witnessed it.
Community services and housing. So curious if we can kind of double click on that a little bit. It sounds like per the CARE Act, in the law, there is a pathway to community services and housing. But those are also very impacted areas, right? So curious, panelists, if you can address sort of how might community services and housing, how feasible is it, and how might it impact other populations? And if you can kind of dive into maybe the concerns or opportunities as it relates to community services and housing.
So the housing piece, it says that we need to address housing and care we provide in treatment delivery. We always do treatment planning and always address someone's residence. So if somebody were in need of housing, we would normally address that. There's no requirement, though. I want to be real clear because that changed. There's no requirement that we house anybody, because that's how it was initially spun, is now everyone has to get housed. If we had enough housing, some of this wouldn't be an issue. We'd still have schizophrenia, of course, but this care probably wouldn't have come along. it is, if you look at some counties that have they can't even have regular housing for dorms for students, much less affordable housing for people who need community supports. So this is going to be an issue. Behavioral health bridge housing is a $2 billion amount of dollars that are made available to counties sporadic. We've just started to be able to apply. Orange County is getting 37.1 million of that, but I haven't gotten it yet. And CARE opens its doors October 1. And that housing will allow me to do short-term and medium-term shelter while I'm finding a place if somebody wanted to find their own apartment, but I don't have the money yet. And so the difficulty is because a bureaucracy is creating all of these systems that are also bureaucracies, we're so slow. So I don't have, I have these awards, but I have no funding yet, and I can't build. And if all of you know, county's super slow. It'll take us at least 5 years to build. So this is a real concern, but I would also really quickly just like to say, if someone is so sick that they're going to die out on the streets without receiving treatment, I'm not putting them in permanent supportive housing. They're going into some place that will keep them safe and address their concerns and their issues and probably help stabilize them. And that's not going to be an apartment. It's going to be something else. And perhaps a boarding care, or perhaps a room and board, perhaps hopefully they go back to live with their family, whatever that is. So it's more than just permanent supportive housing. I think that's an end goal we all want. And we're all working on trying to build that. But I will say there's a lot of impacts coming towards us right now that will affect our ability to build things like that for this population of people in need.
Judicial Council had a work group on homelessness that issued a report in November of 2021. And in that report, the estimate was that California is somewhere between 3 and 4 million housing units short. And so it's no wonder that we see so many people that are unhoused. The bottom line, though, is that without housing, it's, in my experience, extremely difficult to help someone thrive who's got a serious mental illness. It just really doesn't work very well. And so we got to get busy. I don't for a second think this is an easy task. I think building housing in California is very, very challenging for all sorts of reasons. Funding is only one of those challenges, but we've got to do it. There's really no way around it. And I think this is going to be the single biggest challenge of for CARE Court to succeed. And I think it's going to be a challenge for every one of the 58 counties.
I agree with that. I think we've all heard a lot about housing over the last several years, and how unviable the business model is around that, and we continue to lose providers of housing, and that's my concern with CARE Court as well. Having the access to housing is the key to being successful, and there has to be some sort of dependable compensation to the providers of these housing who is out there now, and the sort of piecemeal approaches to compensation for providing these housing. I can't see it being a long-term solution, but there has to be something to prevent it from becoming a contributor to the problem, of homelessness. So I think there's a lot to be done there. And I think, we can't private care courts because we think it's addressing a population that can be saved, and can thrive given the right conditions. And so we have to make housing a priority for this population we've already identified as being salvageable, and we need to do that by really working with the providers of these housings to find out what they need to stay in business and continue to provide those services that are key to the success of this, this CARE Court program.
It would take a massive investment, and by massive, that means massive. And I hear Judge Bianco, and there's a lot of factors involved, and it is frustrating to hear how much it costs to do this. That's beyond my knowledge. Something that is continually occurred to me is like our priorities as a society. If they remain as they do, I'm skeptical, because I keep referring back to there was an effort in Venice a number of years ago, not that many years ago, to build on a city property that was empty. It was for the homeless folks. It had separate areas, male and female, areas for younger people. There was mental health treatment. There was medical treatment. It looked like a great design to me. And I only found out from a friend, on Facebook, and certainly paid attention. And when they came for public comment in Venice, people were wildly against it, incredibly against it. It's not in my backyard kind of stuff. It's and I think disbursement and sharing of the responsibility is really important. And so that didn't happen. There were other things that were done in Venice by the councilman. Yeah, when do we get to this simple point of our priorities as a society? If it's what my home costs, then I'm skeptical, but hopeful.
Thank you to all of our panelists for addressing these high-level questions and diving into it as well. And would really like to transition into the Q&A now. We have so many questions coming in, so just want to really thank our audience for just how engaged you've been in this conversation and in this topic, and how it is a complicated topic, right? There's lots of layers to this, and it's still being worked out. The question is, the CARE Court has been referred to as a bridge to nowhere, in the sense that it would push thousands more people into a system already underfunded. Do we have any thoughts around that?
I would just say that I was using the hallway to nowhere myself, but based on the Winchester Mystery House, where we just tack on things because the legislature told us to do it without any regard for the people who deliver the service, but more importantly, the people who receive the service. So what we're trying to do is, since this is law, is work within the confines of the law, but figure out a way to make it work. And so that's why I think that you're going to see some differences in counties. In Orange County, our judge, like I put in for someone else to read in there in the chat, was our judge is not going to hold this necessarily in a court. If a person won't go to the court, but they're interested in it, the judge will take off his robe and he will go in his own vehicle to the place where the person is, when the public defender will be present to represent the individual. That's who Orange County is utilizing. Or if somebody has a lawyer, we're going to work within the confines of the law, but stretch it as much as we can. I'm sorry, Judge, but and our presiding judge has written minute orders already, so that we know if this happens, then how can we make it more flexible so we can offer people services. So anytime we have the opportunity as a clinician, as a family member, anytime we have the opportunity to offer somebody something different, I don't think that's a bridge to nowhere. It's not the best, but it is a slight opening, a small opportunity for us to try and serve people.
Thank you, Dr. Kelly. Other thoughts and comments?
I agree with the premise of the question that in many counties there just isn't enough treatment. And I see this in conservatorship courts where we can make conservatorship commitments all day long, but there aren't enough places for people on conservatorships to be placed. So they end up waiting in jails, or the conservatorship petition gets dismissed. It's a terrible, terrible thing for the person. But people look to the courts for solutions. So we just keep doing what we can to follow the law. I think CARE is interesting because it gives the court the power to put the county on the hot seat if they're not providing. Now, I think one of two things is likely to happen, and this is a generalization. Either the county is going to create new treatment and expand capacity, which can then be provided to CARE Court participants, or the county is going to take treatment away from people who otherwise would voluntarily engage, and it's going to provide those services to people in care court. That would be a terrible, terrible outcome. So I'm certainly hoping that in most or all counties, option one is what happens. We really need services to be expanded and treatment capacity to be expanded, and I think care court hopefully is going to help us along that path.
So I would like to transition into the questions that came up for when each of you gave your particular presentation. So just starting from the order in which you all presented, Dr. Kelly, would this apply to people with diagnosis of major depressive disorder or severe psychotic symptoms? That's the only one I'm seeing maybe that was not addressed. If you want to.
No, because that diagnosis would be major depressive disorder. The psychotic features is part of it. This is very, very specific. And there are other programs and other, if we had to go that route, other collaborative courts that would address broader diagnoses. But this is very specifically schizophrenia spectrum disorder and related psychotic disorders, not depressive disorders.
Judge James Bianco. So we have some questions for you. We have about 5 or 6. Just
guarantee I can answer at least 3.
Okay, sounds good. And feel free to pass if you can't address for whatever reason. So let's see. How does one benefit from care court more than from true voluntary treatment?
I mean, it's hard to generalize, right? Because people are people and there's no one size fits all. I think if someone is engaged voluntarily in good quality supportive treatment, they're getting what they need, there is absolutely no need for care court. I don't think the court, look, in a perfect world, you wouldn't need the court to be involved in any sort of mental health process or in very, very limited instances. And there are places in the world that I've been to where that's exactly what happens, because they have an incredibly robust, supportive community mental health system that helps everyone that needs it. So there's very, very little need for court involvement there. So I think the answer is it wouldn't be different or better in any way. There's no additional positions, but the court is going to have to shift resources to meet the needs of care court. So that's absolutely going to happen. At least, I know in Los Angeles, there are plans to do that. We don't get more judges, but, we're going to have to shift judges away from other litigation types to and assign them to take care of the responsibilities required under the CARE Act.
If a person has a qualifying diagnosis, but they refuse to engage in treatment, yet aren't meeting criteria for an involuntary hold, in what ways do you think care court could help that individual?
Okay, and I think that's true of a lot of mental health issues, not just people on the schizophrenia spectrum. And, that's a case where the supported decision-making, I think, would come into effect either through that or through family members, if they have that filling that sort of a supportive decision-making role, to help them understand that there are, other options available to them other than their current experience. And having gone through that several times with my own family and other families, sometimes that's the only way you can approach it, is to try and convince people that, there's more to life than you're getting, and it's available to you if you give it, you give it an opportunity.
If a person should lose a housing voucher during an extended jail or court case and loses the voucher, what would be a way a family can support getting it back? We have the first question is that, quote, my understanding is that they are not legally binding in California because the state does not formally recognize PADS. Is that true?
I'll go back and forth with Judge Bianco and Dr. Kelly, but this is what draws my interest, is that they're in this law. And as I understand, if one of these is created, it shall be recognized. But if they aren't used, if they aren't, recognized in real time, if there's a buy-in from behavioral health departments, law enforcement, courts, etc., then I don't know. I mean, the Marvin Schwartz, who is an incredible doctor who runs the National Research Center for PADS. I guess my dog wanted to comment too. Um, um, he says what we need are more people with pads. We need more of them. It's like a supply and demand thing, and that's what I see a hope for in this is there's opportunity to put it in. It's in the language of the law for the first time, as I understand, in California. So maybe Jim, could you respond to whether they would be recognized in a court? Because it definitely is in the language of the law, is one of the options in the care planning process. Would you agree, Dr. Kelly? I'm sorry to spread this around.
Yeah, no, I would agree. And I think the state's looking at, we have a multi-county innovations project that's looking at how do we make PADS in real time and stand up on a platform so that law enforcement would also be able to access to determine what they do when they're coming upon somebody who might be in psychiatric crisis. But that's really up to the state. I think that they're going to be looking at this. Many counties are working with the state right now and figuring out how to activate PADS a little bit quicker. But whether or not it's upheld in a court, different question.
As you pointed out, it is in the law for care court. And in fact, it says that the psychiatric events directive shall have the force of law.
Judge Bianco, is drug-induced psychosis included as an added comorbid that can be addressed in care court?
I would defer to Dr. Kelly. I think there needs to be a primary diagnosis of a schizophrenia spectrum disorder. I don't think a drug-induced psychosis alone would qualify, but that's can sometimes be a gray area, teasing out whether it's just drug-induced psychosis or there's an underlying mental illness that is causing the person to have symptoms.
And that's when the county would look at, do an assessment, and then try and gather it with the patient's permission records to determine what it was, which came first, or if it really is truly drug-induced. But if they have a diagnosis of schizophrenia and they're also using methamphetamine, which that would then absolutely you would treat them both, but the schizophrenia would get somebody into the program, be eligible.
Thank you so much. And we are just about at time. So thank you so much to our amazing panelists here for taking the time to address these questions. And here's all of our contact information, email, website, social media. So please stay tuned, and we hope to see you at more upcoming learning events.